May please, Your Lordship, I beg to mention item number 16, Your Lordship. The senior conducting counsel is unable to come due to some personal difficulty, Your Lordship. 16, 17, and 18. It's a connected matter, Your Lordship.
So 16, 17, 18.
Yes, Your Lordship. I pray that the matter may come up after
You're
2
for?
weeks. I'm for the petitioner, Your Lordship.
On premier by petitioner, this is matter up to 3 weeks.
Obliged, Your Lordship.
May I please, Your Lordship? I would like to mention item number 9. I pray for 3 weeks' time.
You're for?
For the petitioner.
I'm for the state, Your Lordship.
I think this is only for filing of a written argument, isn't it? Or matter has been heard.
No, not yet, Your Lordship, but we have to file written submission.
If it is not yet heard, then on premier by the petitioner, this is matter up to 3 weeks.
Obliged, Your Lordship.
May I please, Your Lordship, item number 10 and 11. I'd like 2 weeks, Your Lordship.
You're for?
I'm for the respondent.
May please, Your Lordship. Lordship, item number 10, 11 and 12 are interconnected, Your Lordship. So if 10 is to be adjourned, then 11 and 12 will have to be adjourned.
He is appearing for respondent in item number 10 and 11.
You're for?
I am for the petitioner in item number 10 and 12, Lordship. And he is for the petitioner in item number 11.
School matter?
Yes, Lordship.
That Hindi teacher, Your Lordship.
On premier by the respondent?
Private respondent, Your Lordship. State is not seeking.
Private respondent? Number? Private respondent. Not objected to by petitioner. This is matter up to 3 weeks.
2 weeks, Lordship. Can we make it 2 weeks, Lordship?
2 weeks.
Obliged, Your Lordship.
Obliged, Your Lordship.
May please, Your Lordship. Lordship, I beg to mention item number 13.
You're for?
For the petitioner, Your Lordship.
What is this matter about? Yes. We don't know what's the facts of the case. Yes, Mr. Tell me.
So we have come against the judgment and order dated 8/2/2017, impugn against the order passed by the Judge District Council Court.
Okay.
Impugn against the order, they filed instant revision, Your Lordship.
On premier by the petitioner, this is matter of the 3 weeks.
Obliged.
May please, Your Lordship, I beg to mention item number 8. I pray that this matter may taken up after 2 weeks.
You're for?
I'm for the petitioner, Your Lordship.
You're for?
I'm for the private respondent number 6 and 7. 7 and 8.
Respondent number 4 and 5.
On premier by the petitioner, this is matter up to 2 weeks.
Have your pledge.
All right.
My lord. My lord, item number 6, my lord. My lord, this is the matter where the Telangana High Court has passed an order, my lord. My lord, that judgment and order, we have preferred an SLP, my lord. So which is likely to come 3rd week of July, my lord. We have preferred that. So I pray that this matter may be after the outcome of the SLP.
On premier by the petitioner, I heard Mr. Jha, letter counsel for the petitioner, who has submitted that a related and similar matter arising out of an appeal before the Telangana High Court involving the petitioner herein, wherein by relevant order, the appeal of the petitioner as the appellant therein was, you are the appellant,
No, my lord, respondent.
whereas the appeal by the Union of India against the petitioner herein as the respondent was allowed, has now been has prompted the respondent to prefer an SLP for the Supreme Court. Since the outcome of the matter to be preferred before the Supreme Court would have a direct bearing on the case of the petitioner herein, it is submitted that this matter may be adjourned for the time being. On primate, same as the law. List this matter after 4 weeks.
My lord. Hello.
Supplementary course list, item number 1.
Which witness?
Lordship, this is a regular bail application, Lordship. Here, Lordship, earlier the petitioner approached this honorable court for invoking 438, Lordship. However, the pre-arrest bail was dismissed by this honorable court by order dated 28 April 2023, Lordship.
POXO matter?
Lordship?
Is it a POXO matter?
No, Lordship, no. 397 and 395, Lordship.
Okay. Or
So
dacoity?
while dismissing my application, my lord has given an observation that his custodial interrogation is needed. That is why my pre-arrest bail was rejected, and on the very same day, Lordship, before the order was uploaded in the High Court website, Lordship, and 3:30 to 4 he was arrested, Lordship, on 28 April 2023. And since then he has been inside the jail, Lordship. It has been more than almost 70 days, Lordship.
What is the stage of the case?
Case, Lordship, investigation, Lordship. It's still under investigation.
Charge has not been filed?
No, Lordship.
Lordship, they had approached, after the arrest, they had approached a trial court also twice, Lordship, for moving bail. Lordship, twice it was rejected because,
No, the query,
Lordship,
Miss, the query of this court is, was charge sheet filed in this case?
Lordship, I have to seek instructions, Lordship.
Otherwise, he's 70,
No,
years,
Lordship.
70 days.
67 days, Lordship, as of today.
Even then,
I'll seek instructions, Lordship.
you should have have you preferred an application under section 167?
167, Lordship, this is 90 days, Lordship.
Oh, it's 90 days.
90 days, 90 days, Lordship. 90 days. Lordship, because 67 days going to be 7 days, enough time for the for the IO to investigate that matter.
No, if that is the case, then we'll...
Yes,
have
and
to
in
seek,
fact, in
instructions,
the FIR also, my name is not reflected. Why I was
So
involved?
let
Because
the CD be produced.
Lordship.
why the allegation was that because my driver was alleged to have been involved in the offence, and my car was alleged to have been involved in the offence, Lordship. That was the allegation was put against me.
Lordship will produce the CD, Lordship. The records speak for themselves.
A copy of the CD is only.
Copy of the CD, Lordship.
Mr. Associate Legal Counsel for the petitioner, who has submitted that this application for grant of bail has been moved under section 439 CRPC, seeking bail on behalf of the
Accused person.
son of the, he is the son of the son of the petitioner, who is an accused and is in custody in connection with Pulvari PS case number 48/6 of 2022 under section 397/395/34 IPC. Before proceeding with the matter, on a query made by this court, the learned senior GA, Ms. Anjishela, has submitted that instruction may be allowed to be sought for as far as the status of the case is concerned. Be that as it may, the matter will now be posted for hearing on the next date, and the state respondent is directed to produce a copy of the CD, copy of the latest status report, including the CD, on the set date. As prayed for, this is matter after 1 week.
1 week, Lordship.
1 week.
July, Lordship.
Hi.
This is a 482 application, my lord, in view of the compromise between the parties. This is the same matrimonial matter, my lord, which whereby anticipated bail was granted by your lordship last week, my lord. In this matter, my lord, at page 24, my lord, page 25, page 24-25,
Yes.
is the memorandum of settlement between the husband and wife. And your lordships, at page 31, that is part B, paragraph 7, page 31, paragraph 7, my lord, the parties, the husband and wife,
Yes.
this is paragraph 7 of part B, my lord, of the agreement,
Yes.
have agreed to, my lord, close and settle all the criminal matters, my lord. My lord, at page 39 is a compromise deed, my lord. Why a separate compromise deed? Because the FIR is also directed against the father-in-law, mother-in-law and the sister-in-law. So therefore, my lord, this compromise deed is between the complainant and all the persons, the husband, the father-in-law, mother-in-law and sister-in-law, against whom the FIR has been lodged, my lord. Page 41, my lord. Paragraph 1 and 2 will be relevant of the compromise deed, that the parties have settled the differences, my lord. Now, my lord, I am before your lordships
You're only on behalf of the
on behalf of the petitioners, my lord, all the petitioners, and my lord, I have served copy upon the state, but the private party, my lord, Mr. Sharma. Yes, my lord. So we'll serve a copy upon them also.
You are representing. If you are seized of the matter, then we'll hear the matter.
No, Your Lordship, we have not received the petition, the copy.
So we'll serve a copy, my lord. May have it tomorrow, day after, any day, my lord. I'm relying on
given some 3 weeks time, Your Lordship. We'll file a reply and we'll do the hearing also.
Why 3 weeks? 1 week.
Okay, Your Lordship.
Two judgments, my lord, by your lordship on section 498A, my lord. One is
That will be that at the time of hearing, Mr.
Yes.
Nobody can
My lord.
heard Learned Counsel for the petitioner, Mr. Liman Nongri, who has submitted that this application preferred under section 482 CRPC is made with a prayer to quash the criminal proceedings. Where is your prayer?
Lord, FIR dated Lord Sadar PS case number.
Quash the criminal proceedings in Sadar PS case number 215/9 of 2022, arising out of an FIR filed by the FIR dated 14/9/2022, filed with the respondent number
2, my lord.
2 herein. However, at the outset, the Learned Counsel has submitted that notice may be allowed to be issued upon the respondents. Ms. Shyam, Ms. Shyam has Learned G has accepted notice on behalf of the respondent number, state respondent number 1. Ms. has also accepted notice on behalf of the respondent number 2 and has made a prayer that the copies of the petition may be handed over to her,
which I have handed over, my lord.
which has been done so at the bar. You file your power. You have not filed your power.
No, sir.
Accordingly, as prayed for, this is matter for hearing after 1 week.
Item number 3. May it please, Your Lordship. Your Lordship, if this matter can be taken up after some time, Your Lordship.
Yes, what is this matter about?
Your Lordship, actually my senior wants to come and give submission, Your Lordship. He's in the other court, Your Lordship. He's having hearing. Lordship, just after some time.
My respectful submission, because there is a private respondent matter. So
Yeah, you still.
to the private.
Your Lordship, just after some time, Your Lordship, he's just here. Just after a few.
Immediate next matter will be mine, my lord. Justice, thank you, Scott.
Okay, we'll look at it then. Since notice is to be issued,
My lord, not,
your colleague can be there.
my lord.
What you like?
End of the board.
MDD cost list, item number 1.
Good morning.
They are bail appeals, my lord. We have come against the grant of bail, my lord, in NDPS cases. Now there are 4 matters, my lord. Item number 1, 2, 3, and 4.
Vishnu, item number 1.
Item number 4, sir.
Item number 1 and 4, they are appearing, my lord. 2 and 3, we have received the Postal Department report, my lord. We will file that by one affidavit, my lord. Just yesterday we received, my lord, for 2 and 3.
So you want to hear the matter altogether, or
can we hear together, my lord?
But it's the same case.
It's arising out of the same case, my lord. 4 different accused.
custom matter?
Yes, my lord. It's by DRI, my lord.
DRI, yes.
There is a branch of customs.
Your Lordship, I'll be filing my power during the course of the day.
Oh, you have not done so?
No, he's received the notice. He'll be the respondent will be appearing shortly. I'll be filing it during the course of the day.
And Your Lordship, I have filed for item number 4 as I have received a copy. For rest of the item, I have not received a copy.
Rest of the items you are appearing in other matters also?
As of now, only for presenter, sir, because we have received copy only for presenter. Because in the lower court, we are doing for need to Depu and presenter.
But lower court, they represented. You received
you seek, then you seek instruction. You just give her some extra copies. Not necessarily that she'll accept it officially. In case you get instruction that you'll be appearing for them, then you can make a submission on next day.
Yes,
in the meantime, you file the Counsel Dr. N. Muzika, DSGI, appearing for the petitioner, Union of India, has submitted that the service of notice upon this is item number 1.
One is received, Your Lordship.
On the respondent has been completed. In fact, Mr. S. Yarab, Learned Counsel, has now entered appearance on behalf of the respondent sole respondent, but has also made a prayer that the power may be allowed to be filed on the next date fix. Accordingly, on prayer made, list is matter for hearing after 3 weeks.
And I have filed my power.
Just one at a time.
Apologize.
Item number 2.
Service is complete, my lord. Here we will
So
file an
into
affidavit.
you
Your Lordship, I have not received a copy.
into I know to get you first portion more. I Dr. N. Musical DSGI, appearing for the petitioner, Union of India, has submitted that the service of notice upon the respondent has been confirmed, duly served. However, it is prayed that an affidavit of service may be allowed to be filed in this regard. As prayed for, seems allowed. List this matter after 3 weeks.
Item number 3.
Number 3 will follow number 2, my lord.
So, same order.
Item number 4.
Same as number 1, except that this is file local now.
Yes, Your Lordship.
Katu same as number 1. I compare thing. 80% power is to be filed, has entered appearance on behalf of the respondent, sole respondent. As prayed for by parties, list this matter for hearing after 3 weeks.
Good evening.
Good evening, Your Lordship.
Item number 5.
Lordship, in this matter, I received instructions to appear for respondent number 2 and 3. So I'll be filing my power in due course, Lordship. So I'm praying for some time also to file my counter.
Petitioner is present. Mr. P. Nombri, Learned Counsel, has entered appearance on behalf of the respondents 3 and 4.
2 and 3.
2 and 3 respectively, and has submitted that he may be allowed to file the power in course of the day. State, have you filed the counter? Ms. Iriwa Learned G, appearing for the state respondent, has submitted that the counter affidavit could not be filed today since instructions are still awaited in this regard. As prayed for, this is matter after 3 weeks.
Item number 7.
Yes, Mr. Haneka.
Yes. May I please, Your Lordship? This is the matter regarding the Nokma dispute between two parties, my lord. Here is, before starting, my lord, I have a complaint in respect of respondent number 5 before going to the details, because respondent number 5 is not related to the matter of the Aking dispute, Nokma dispute. He is a totally a strangers, and strangers in the dispute of the Nokma dispute, he cannot participate in this case. So only for the respondent number 5, the entire matters is vitiated, and previously nobody making any objection for that, because he is not related to the Nankra claim, or he is any related to the respondent number 4, my lord. He is not the Nankra claim people.
Then why have you arrayed him as a respondent?
Huh?
Why have you made him a respondent?
No, because it is coming from the district council, my lord, because we have challenged. In district council, he was also a party. That is the reason we have to make him a party.
That since he has been made a party, even in the district council,
Yes.
and you have also read him here as a
Yes,
so
yes.
he is he represented?
He should make it within the lower court.
Whatever the case may be.
No, anyway, that is there by mistake or otherwise they have made. That is my argument, my lord.
The matter will be heard on merit.
Yes, matter will be heard.
Whatever materials you have against him, but who is representing 5?
Yes.
Who's
You.
representing 5?
I am representing 4 and 5 laws.
4 and 5. Okay, fine.
Actually 5 laws.
No, that is my objection, my lord.
That is the material.
What
that is
kind of
protected.
objection it is, my lord?
Now at least
Now, he was before the trial court. He was before the trial court. They have never challenged the locus of the respondent number 5. I am not submitting on behalf of the respondent number 5. But a peculiar kind of situation has arisen where my senior is pointing out that he has an objection for respondent number 5, my lord. Respondent number 5 was a party in the trial court.
No, that is okay. That is okay. No.
Let me finish.
Just I am telling that is myself is my argument that he is vitiated the matter by wrongly or rightly.
Whatever the case may be, Mr.
Yes,
Adhika,
yes. Now I will go.
You have filed a petition.
Yes.
That petition will be heard.
Yes.
Whatever the role of the respondent 5 is, you point it out.
Yes.
And
now,
if it is found relevant, it will be taken into account. If not,
that
it
is
ends there.
No. When
that
that
can get vitiated, even if he has no role. He was before the trial court. He was before the appellate court.
No. That is
now he is before the writ court. My lord.
That
how the entire matter can get vitiated? Can he explain, my lord?
No. That is my argument, my lord. Whether it is accepted by the honorable court or not,
so
that is another question, my lord.
Exactly. So
exactly. That is my intention.
So you
not any other things, because I have admitted.
So you state your submission.
Yes.
State your submission, and the matter will be considered.
Yes, my lord. Now I am coming to the GT, my lord. That is genealogical tree of the Nokmas in page number 19, my lord, of the writ petition.
Mr. Iyer, please refresh this court on the facts of the case.
Yes.
And how you have come.
Yes.
To what extent you have covered the case.
Now I am coming to
what is the main dispute here? Was it against an order passed by the executive committee?
Yes.
Was it passed by the appellate court?
Yes.
All that thing.
So I am going. Yes, I am going to the serial of the fact, my lord. Fact, my lord.
Fine.
So here is the parent of the petitioners was appointed as a Nokma White Order 3rd March 1978 by the chief executive members.
So parents of the?
Parents of the petitioner here, my lords. On 3rd March 1978, my lord. Thereafter.
Where is the appointment?
Yes, that is coming. Page number.
Annexure?
Annexure 2 and 3, page number 20, 21, to 20 to 23, my lord. A type copy.
20 to 23 is a court's order.
Yes. Oh, it is coming
20
here.
to 23 is the High Court's order, my lord. Guwahati High Court's order.
No. I am coming to that. Against this order, my lord. Against this order.
First, point out.
Yes.
You said.
Against this, agree by this order, my lord.
First, show us the appointment of your parents as
yes.
Nokma.
That is.
You have started on that premise, so.
Yes. Where is that order? Huh? Parents of my order is, you see the other, huh? No, it is not there. 12.3. It is not here. That order is not enclosed. It is there.
Where in your petition have you stated this fact?
Yes.
Paragraph?
Paragraph is in the two. Paragraphs are 7 and 8, my lord. So 8, my lord. Paragraph 8, page number 10, my lord. Shall I read out, my lord? Para 8. That the brief fact of the case is that Sri Jongshan Momin married to Srimati Rane and Marak, who are the parent of the present petitioner number 1 and has been declared as Nokma 1956-15 Nagra Aking Land White Order dated 3/3/1978 issued by the Sikh Executive Member GSADC Tura and thereafter being aggrieved by the order Sri Alipshan Marak and his wife Mene Marak, parents of the private respondent number 4, filed a civil rule before the Honorable High Court, Guwahati High Court, which was registered White Civil Rule number 936 of 1982.
Yes, you have made that point.
Yes.
What is your next point?
Yes. Challenging the order of the GSCDC on various grounds. However, it is pointed out that while the proceeding was going on, Sri Alipshan Marak and Srimati Menear Marak, read petitioner, withdraw the civil rule, being not desired to press the petition. Accordingly, it was dismissed. White order dated 5/3/1992. And it is also stated that thereafter the parent of the petitioner number 1 has been continuing as Nokma Nekra Aking land, and after the death of the petitioner parent, the present petitioner supposed to be succeeded to hold the post of Nokma, but during that relevant period of time, she was still a minor. So the clan people Mahari Isras unanimously selected uncle and aunt of the petitioner number 1, Sri Shimrang Momin and Srimati Shura Nankra Marak as Nokma of Nankra Aking land. Accordingly, the district council registered their name as Nokma White Order 17/2000 passed in WPC number 9 AC of 1992-93. It is also stated that when the petitioner attained majority and age, Shimram Momin and Shura Nankra Marak relinquished the post of Nokpaship in favor of the petitioner and her husband, present petitioner number 2. Thereafter, the clan people unanimously selected her as Nokma of their Nankra Aking land and forwarded their name for registration in the GT, that is genealogical tree of the Nokma family, and since then petitioner has been functioning and performing their duties as Nokma of Nankra Aking land. However, it is mentioned that the District Council Authority White Order dated 23/12/2003 by manipulating the entire matter had wrongly entered the name of the private respondent number 4 in GT by setting aside the order 17/2000. So the controversy started, but the petitioner has been continuing as Nokma of Nekra Aking land, being the direct descendant of the Nekra Aking clan, and has got absolute right to hold the post of Nokma of their Aking land and continuing as such till death, my lord. It is in Annexure 2 and 3, my lord. Yes. Annexure 2
That
and
is the
3.
court's order.
Yes, my lord.
There is nothing on record to show that the petitioner parents was the Nokma. There is
No.
nothing.
It will be there. It will be there.
My lord, he's saying annexure
No,
1 and
if
annexure
it is
2.
not there.
So I'm saying about annexure 1 and 2 only, my lord. There is nothing
No,
to show.
I am coming to 1. 1 I am coming, yes. GT, my lord. GT is page number 19, my lord.
19.
Yes. Junction moment is there, my lord. Down is 3.
Yes.
Thereafter, allusion, one note is there. You bring that one. It is detail is there in the green paper. Junction moment is the Nokma here.
But Jongsang Momin is not the father of the petitioner or mother of the petitioner?
No, that is
the question.
you make it an argument later on. You make it, no problem. That is your part.
I'm confused.
Anyway, we'll see. Let us hear what he has to say.
They will be confused only. Then I am coming to my additional affidavit, my lord, because some annexure are missing in the writ petition. So I have filed my additional affidavit, my lord.
Additional fee dated?
Yes, dated is
Dated?
April, my lord. April, that is not there. In the April additional affidavit, and closing the document only some.
Just a minute. April?
Yes.
April, which year?
2023, my lord.
2023. Yes.
In additional affidavit, my lord, page number 2, para 2, my lord. Just I will read the brief fact of the case, my lord.
Yes.
That the Sri Junction Momin married to Sri Rane and Marak, who was the parent of the present petitioner number 1, and appointed as the Nokma White Order 3rd March 1978. Thereafter, the order was challenged by late Alipshan Marak and late Menear Marak, parent of the private respondent number 4, by violating this civil rule number 936/1982. However, it was dismissed on withdrawal. White order dated Ato, and thereafter the parent of the petitioner has been continuing as Nokma of Nankra Aking land, and after their death, the clan people selected the uncle and aunt of the petitioner number 1, namely Sri Shimran T. Shangma and Srimati Sura Nankra Marak, appointed as Nokma White Order 17/2000, passed in GDC case number 9 AC of 1992-93, and it has been mentioned in the writ petition in Annexure 3, page number 2023, my lord. Then para 3, my lord.
Yes.
That the respondent number 4, being aggrieved by the order 17/2000, prefer an appeal before the chief executive members, GSAD Tura White appeal number 2 of 2000. After hearing the parties, the learned chief executive member, GSADC Tura, pass an impugned order on 23rd December 2003, set aside the order dated 17/2/2000 and directed that the respondent number 4 to be registered Nokma of Nankra Aking land and to correct the GT accordingly, and thereafter controversy arose among the parties. So Annexure 1, my lord. Annexure 1 type copy is page number 14, 15, my lord. I will go for the relevant portion only, my lord, in page number 16. Para 2, my lord.
Yes, ma'am.
The counsel of the respondent submit that the written argument in this argument is mostly stressed on the law point and the provision of the CPC.
You are reading page?
Page number 16, para, second para, my lord. On the relevant portion.
Yes.
The counsel of the respondent submit the written argument in his argument. He mostly stressed on the law point and the provision of CPC. He also submitted point of agreement on the decision of the Honorable High Court in which the case before the High Court was withdrawn. I have perused the written argument filed by the counsel of the respondent. As discussed above, the appellant is direct blood relation to the Nokdang lineage, and thus she was every right to the Nokmaship of Nankra Aking. On the other hand, the respondent did not have any link to the Nokdang lineage Nankra Aking. Their claim is only through the withdrawal of the case pending before the High Court. This claim cannot consider for Nokmaship. In view of the above discussion, I set aside the order dated 17/2/2000 passed by the executive member revenue. I doth order that the Srimati Medalin Marak Misik Nankra be registered Nokma of Nankra Aking, correct the GSTT. I pass no order. This order again has been challenged by the petitioner, predecessor of the petitioner, my lord, Sura Nankra Marak and her husband Shimran Momin, in page number 18, my lord. So I will go for type copy, my lord. So that one also readable, my lord.
Yes.
All right, page number 18. I will go for content, my lord. Judgment and order oral.
Yes.
Dated 21st March 2006, my lord. We have challenged this order of 23rd December 2003, my lord. Heard Mr. S. Sen, learned counsel for the writ petitioner, and Mr. A. S. Hazure, learned counsel appearing for the respondent number also. One also heard Mr. K. S. Kinjing, senior counsel appearing for the respondent number 2, 3, and 4, assisted by S. Kharmi advocate. None has appeared on behalf of the respondent number 5. This writ petition has been challenging the appellate order dated 23rd December 2003 passed by the learned Chief Executive Member Garo Hill District Council Tura, whereby in several of the order dated 17/2/2000 passed by the learned Executive Matter Revenue case number such and such, the respondent number 1 in the writ petition has been declared to be Nokma of Nankra Aking. The case is a long and secured history. Therefore, it will be necessary to briefly notice the relevant fact before delving into the adjudication of the dispute raised by the parties. Second, The convenient starting point of the aforesaid narration of the relevant fact could be date of the earlier order, dated 23rd 7 1976, passed by the learned executive member in charge revenue GDC in case number such and such 35 AC, by which one Alipshan Marak and his wife Mene Marak Misik were appointed as the Nukma of Nankra Aking land. The aforesaid person were appointed as the Nukma are the predecessor of the present respondent number 1. Against the aforesaid order dated 23rd 7 1976, passed by the learned executive member, once Jongshan Momin and his wife Rane Marak, my lord. That is my mother here. They are challenging that he is not related. Jongshan Momin and his wife Srimati Rane Marak filed miss case number 12 of 778 before the learned chief executive member of the district council. The learned chief executive member of the district council prepared and signed the judgment dated 3rd March 1978. Next para my lord. Declaring the appellant Jongshan Momin and his wife Rane Marak, that is my mother, my lord, filed the case as the Nokma of Nankra Aking. However, before judgment could be pronounced, the district council was superseded and an administrative was appointed thereafter. As the judgment was not pronounced, the matter reached this court in Civil Rule number 478, which was disposed of by this court on 12 September 79, directing the chief executive member of the district council to decide the appeal in accordance with law. Thereafter, by an order dated 25/3/82, passed by the administrator of the district council, a decision was taken that the order recorded by the previous chief executive members on 3/3/78 should be pronounced, and accordingly the same was pronounced. Aggrieved, the predecessor of the present respondent number 1 challenged the aforesaid appellate order dated 3/3/78 as well as the order 25/3/82 of the administrator directing the pronouncement of the said judgment and order dated 3/3/78 before the High Court in Civil Rule number 936/82, which was eventually withdrawn by the petitioner on 5/3/92. Thereafter, sometime in the year 93-94, the present petitioner had approached the executive member of the district council for recording their name as the Nokma, claiming the right of relinquish on the basis of being legal heirs of the Jongshan moment. It is on the aforesaid claim that the impugned order dated 17/2/2000 passed by the learned executive in charge revenue, which has been reversed in appeal by the impugned order dated 23rd December 2003. Para 4. A consideration of this order 17/2/2000 passed by the learned executive member in charge of Revenue District Council in favor of the present petitioner would go to show that eventual conclusion recorded in the said order was based on consideration of the earlier order passed in this regard. That is the order of 23rd 7 1976 passed by the learned executive member in charge revenue and the appellate order 3378, while reversing the said order, the learned chief executive member by his impugned order 23rd December 2003 has been recorded the finding that it is the respondent number 1 read petitioner into this thing, executive member, who was related by blood to the original Longpa and the next page, my lord. And the withdrawal of the writ petition registered as CB rule number 9682 by the predecessor of the respondent number 1 appellant would be no consequence. The learned executive member, while rendering the appellate order dated 12 December 2003, has not indicated the basis on which the conclusion that present respondent number was directed. Blood relation of the original Nokma has been recorded, my lord. Here, my lord, the present here respondent number 4, only for short span of time, her father was the Nokma. Thereafter, the junction Momin and Rane Marat has been continued to be a Nokma of the Nankra England till 17 February 2000, my lord. Thereafter, another Sura Nankra coming, my lord. The aforesaid appellate order 23 was also does not reflect any consideration of the earlier order passed by the learned executive member. The learned executive members on 23rd 7 1978 and 3/3/78 respectively, if the person petitioner claimed to be legal heir of the junction moment, surely and certainly the aforesaid claim made by the petitioner ought to have been considered by the learned executive in the light of the order dated 23/7/76 and 3/3/70, in which the order and the claim of junction moment to be recognized as the Nokma has been elaborately dealt with. That is the most important, my lord. In any case, there being previous order with regard to the claim dealt with by the appellant order dated 23rd December 2003, it was incumbent on the appellant authority to duty and to properly consider the legal effect of the said order. The finding recorded therein, as well as the basis for which the finding as indicated in the order in question, the aforesaid course of action not having been adopted, important, my lord, by the learned affiliate authority, that is CGM, Chief Executive Member, I am of the view that apparent and discernible infirmities have been crept into the impugned affiliate order 23rd December 2003, which call for this court's interference, my lord. Now, para 5 is important, my lord. Accordingly, I enter with the order 23rd December 2003 passed by the learned chief executive member, Garhwal District Council in appeal case number 2 of 2000. In the fact and circumstances of the case as noticed above, I remand the matter to the learned chief executive member for a de novo consideration and for passing fresh order after hearing both the parties, after taking into account the earlier order 23/7/76 passed in GD case number 35 AC 1975-76 by the learned member in charge revenue, and the order 3/3/78 passed by the chief executive member in MES case number 12 77-78. The learned chief executive member, next page, my lord. shall decide the matter at the earliest, and the court is confident that such decision would be rendered by the learned chief executive member within outer limit of 4 months from the date of receipt of a certified copy of this order. The writ petition consequently allowed to the extent indicated above. That is the order of 23rd December 2003 is already established, my lord. Thereafter, my lord,
Yes.
thereafter I come to thereafter what happened, my lord? Then I come to para 5 of my additional affidavit, my lord.
Yes.
That when the chief executive member GSAT Tura is not passing any order in pursuance of the Honorable High Court Order 21st March 2006, then the ex Nokma late Sura Nankra Marak and her husband late Simran Tin Sangma filed an application before the chief executive member Turayato. The chief executive member GSADC without taking evidence passed an illegal order.
We are reading which part?
No, this additional affidavit, page number 4, para 5, my lord. That document I have not
Yes, yes.
enclosed before in the writ petition, my lord. So I am reading from here. Para 5, my lord. Now, that shall I read, my
Yes,
lord?
please.
That when the chief executive member GSS Tura not passing any order in pursuance of the Honorable High Court Order 21st March 2006, then the ex Nokma, that means late Sora Nankra Marak, Harvard's late Simram Tin Sangma, filed an application before the chief executive member GSADC Tura and the chief executive member GSAD Tura without taking evidence passed an illegal order on 10 January 2013 in appeal number 5, wherein it is mentioned that only that the parties present heard their learned counsel submission, judgment and order is pronounced in an offence court which prepared in a separate sheet. Appeal is allowed, case is done, disposed of. Whereas in this case, no order has been passed, my lord. I am coming to that point. And thereafter, the petitioner number 1 make an application dated 28 January 2013, request to obtain the detailed judgment and order of 10 January 2013. However, no action has been taken thereafter. Thereafter, the Sura Nankra Marak addressed a letter to the chief executive member on 4th February 2013. However, the judgment was not provided to them and verbally informed that no order has been passed till date. Accordingly, the petitioner was not able to not able to obtain the final judgment and order 10 Atho, wherein the last paragraph it is mentioned that in view of the Honorable High Court order, further delay should not be avoided to arrive at final settlement fixed 15/5/2013 for step. However, it is regretted to state that no order has been passed. So I am coming to Annexure 3, my lord.
Annexure 3 of this additional affidavit.
Yes, additional.
Each.
Page is 19, type copy is 31, my lord.
Let's go to 31.
Yes.
Yes.
Here. Medallion Marak appellant then versus Shura Nankra Marak 10/1/2013. That is the order, my lord.
Yes.
Parties present heard their learned counsel submission. Judgment and order is pronounced in an open court, which is prepared in a separate sheet. Appeal is allowed. Case stand disposed of, whereas no order has been passed, my lord. Thereafter, my lord, no order has been passed. Then in case number 32, my lord, as we could not find any this thing, so we have make an application to the chief executive member to supply the copy of the order, my lord. Page number 32, dated 28 January 2013, my lord.
Yes.
They could not supply, my lord.
Yes.
Then we have make, when we are not getting any judgment and order of 10/1/2013, my lord, then we make another application. Page number 34 and 35, my lord. 35 is the type copy, my lord.
Yes.
We have written to Secretary Executive Committee, Garhwal Autonomous District Council, Tura. Humble request to issue necessary direction to concerned person of Judicial Revenue Section to obtain the judgment and order dated at all.
Please, Lordship.
No, please wait.
Sorry to interrupt. Actually, this what my senior is arguing. This already covered the judgment. This is just a procedure. This application that has already deal in the judgment, Lordship, because this is
because
unrelevant, Lordship.
No, here, my lord, what they are challenging, which order I am challenging, it will come now.
The order is there already. This is just an application.
You have read the order of the High Court.
Yes.
Where the CM was directed to hear the matter.
Yes.
CM ostensibly heard the matter,
Yes.
but and then pronounced the judgment.
Yes.
But the
no judgment.
But the copy of the judgment is not on record.
Yes.
So thereafter, what did you do?
Yes. Thereafter, I am coming to that point, my lord.
That happened. What happened actually? There was a change of CEM. There was administrative.
No.
There was a the JHTC was there was a collapse of the government at JHTC, and subsequent there was a change of CEM. That's why they were not able to pronounce the judgment.
That does matter. That does matter. Let's see.
No, a sequence.
How is the petitioner aggrieved by non-passing or
of the order?
Maybe the order may have been misplaced, whatever.
Well, this non-passing of the order doesn't come into play in this proceeding.
No.
In this proceeding, just a minute. In this proceeding, my lord, my learned senior has to point out what is the lacuna or what is the defect of order dated 15/12/2016. Because all this argument what my learned senior has placed has been covered up.
No.
Has been covered up. Now he has to just point out, my lord, before this honorable court, what is this case.
I am interfere in this matter, my lord. Let me complete it.
See, Mr.
Yes.
Jarika, if
you should not hit around the bush.
Yes, if the matter has already been covered by the impugned order.
Yes.
All these things have been released. You don't need to
Everything is reflected in that order.
That is not the reason, my lord. Because of this order, non-supplying of the order of 10 January 2013, we have filed a writ petition before this court, my lord. That is the.
Yes. So. Anyway, it is his case. So.
No, I feel my lord.
No, my lord. After finishing, if my learned friend from the opposite party anything to say, let them say. In the middle, I don't think it is appropriate.
But the only thing, Mr. Ajay, you have to bear in mind.
No.
You have to keep in mind that you cannot waste judicial time.
What I'm pointing out is this directly, my lord, is that he is wasting the time. He is hitting around a bush. He is not addressing this honorable court on 15/12/2016.
Let me wait for 5 minutes, my lord. They have to answer it.
Fine, you continue.
Yes. Let them answer. How do you answer it?
Excuse me.
I will be here only, my lord.
Please continue.
Yes. Then 2 applications we have filed for not providing the order of 10 January 2013, my lord. Thereafter what happened, my lord? They have passed another order on the same date in page number 36, 10/1/2013. How that they have manipulated this thing. In the same day, 2 orders has been passed, another is allowed, case is disposed, but no order is there.
10?
Same, 10 January 2013.
Page number?
Page number 36.
36.
Yes, annex or 6. You go through it. After my finishing, you make an argument. No problem. I am not wasting the time of the honorable court, but because it is correlated. Only for that we have filed another writ petition. And what my learned friend is telling, his mouth will be mum only after hearing this order.
Yes.
Then I come for this type copy, my lord. Page number 58.
Yes.
The dispute, final judgment and order, my lord. That is writing. That Shora Nankramara Simrang versus Meghalaya.
Yes.
The dispute between the parties to successor to Aking Nokmaship of Nankra Aking 5615 belonging to Nankra Aking clan. The history of the dispute date back 1973 when a petition was filed recognition of registration of late Mene Nankra Marak and husband Alipshan Marak, the predecessor in interest. Srimati Madalin Marak for the registration and recognition as Aking Nokma by the Revenue Authority before the executive member in charge of revenue, Garo Hills Autonomous District Council, Tura, White case number 35, 1973-74.
This order was set aside by the Honorable High Court. This order.
You will know all this thing in the middle. Why
are you reading the?
No.
This order has been set aside.
No.
Only what the point out only the salient features or the relevant portion.
It will go serially, my lord. It is related to each other.
High Court has set aside this order.
Anyway, let him.
Probably he's.
No. Probably what is there, if you have got enough time. The petition was Alice agreed and supported by the Junction Momin, husband of the late Register Lokma Jamse Nankramarak. It is said Junction Momin was released from Aking customary between the claimant of this thing and wife to supply substitute on the death of either of the spouse to maintain continuity of the relationship of the claimant, and Junction Momin also relinquished his position as male Aking Nokma in favor of Mene Nankra Marak and her husband Alipshan Marak. However, at the time of Maujadar inquiry, at the beginning of the proceeding, he also reclaimed his Aking Nokmaship after remarrying Lady Rane Marak of Nankra clan. The CM after Nankra married this 3378, he is continuing as a Nokma of the Nankra King land, my lord. That is important point, my lord. The EM
has been set aside. How it can be irrelevant?
Please wait. You have got enough time. Why so much this thing? The EM in charge revenue passed the final order 23/776 directing the Menem Nankra Marak and her husband Alipshan Marak to register as Aking Nokma. His judgment was based on the inquiry report. This is the most important, my lord. Based on inquiry report dated 1/5 1978 and enclosed statement of the parties and claim member and the documents submitted to the Mojada during the inquiry. Rane Marak, that is my mother, and Jongshan Momin, the file and appeal before the chief executive member dated 23/7/76 in repetition number A77, the CM not being satisfied with the trial of the EM proceed to evidence some witnesses produced by the appellant on the basis of their statement as set aside on 23/7/76. Further proceeded to appoint and register the appellant. Here, my lord, important. Appellant Rane Marak and Jongshan Momin, White Final Order 3378. The final order 3376 could not be pronounced by the CM due to the dissolution of the Executive Committee, GSAT, taking over by the administrator. The delay in passing the final was again challenged in the High Court by filing Civil Rule number 400 1978, my lord. The High Court by its order dated 18/1/80 directed the CM to dispose of the appeal, my lord. Important. The administrator P.J. Bazley, Deputy Commissioner acting as an administrator, simply pronounced the order 3378 passed by the CM on 25th March 1982 as mentioned earlier. The CM set aside the order passed by EM 23/776, that is the order of respondent father, parents of the respondent number 4, my lord. It is set aside. Proceeded to appoint the appellant, that is Jongshan Momin and his wife Rane Marak. The disputes were taken in the High Court in the form of the petition civil rule number 1936. That one is already this thing dismissed, my lord. So it is already dismissed by the Honorable High Court on withdrawal. Then thereafter the dispute surfaced alleging that the petitioner did not pursue the writ petition civil rule number ATO and was dismissed on 5/3/92. Shora Marak and Jongshan applied for EM for their registration by filing case number 9/92/93. During the pendency of the case, Alipshan expired. One Caxton Marak was substituted in place of Alipshan Marak. It appeared that the issue were framed, but the case was finally decided in favor of the petitioner on the ground of res judicata by passing the order 7/2000, my lord. That is Shura and Nankra. He had to pass in favor of my predecessor, my lord. Again, what happened, my lord, in the next? Against the order of, now it will go serially, my lord. At an appeal, GDC number 2 was filed by the Mane Marak. During the appeal period, the Mane died and her place the daughter Madeline Marak substituted. The appeal ended by passing the order 23/12/2003 by the CM to register the appellant Madeline Marak to be registered as Aking Nokma, which reflected reversal in the order dated 12/2/2000, my lord. The final order dated 23rd December 2000 lead filed their writ petition. Then again one writ petition was filed, white number such and such in 2000 from. Then re number is 247 SS 2004 by Shura Nankra Marak and Shimran Momin. The petition was disposed of 23/2006. The High Court interfered with the order 23/12/2000 passed by the CM, remanded the matter to CM for de novo consideration and for passing the fresh order after hearing both the parties and to take account of the earlier order 23/7/76 passed in the session 35 of 75/76 passed by the EM, order dated 3/3/78 passed by the EM. Miss appeal number ATO, correct appeal number is GDC revenue number 12 of 1977-78. The CM further directed to decide the matter within the out limit, my lord, of 4 months from the date of receipt of certified copy of the order dated ATO. Medali Marak approached this court with a petition enclosing the copy of the order 23/3/2000 passed by the High Court in WPC number 246/2000 series, with prayer to transfer and remand the case to EM on the ground that the order has been passed for de novo consideration of the case. It will be appropriate if the case is tried by the EM, the court of the first instance, as the court of CM is appellate authority and can consider, if necessary, any appeal out of the de novo consideration by the EM. The CM transferred the case EM, White Aking petition case number 1 of 2007 by the order 23 March 2007, my lord. It is noted that EM registered the case, started to take the fresh case of 2000 revenue number 5 of 7, but vehemently objected by the Shura on the ground that the High Court has specifically directed the CM to consider the matter de novo. The case was retransferred to the court without going into the merit of the case, my lord. And then next page, my lord. Or shall I go for the concluding?
You go then.
Concluding.
We were telling you all along.
Yes, very.
Now he's tired probably. Reading.
Now.
Yes.
Now this, I am coming to the operative part, my lord, page number 65, last para. I have considered 2 orders. Last para, my lord, page number 65. I have considered 2 order, vice order dated 23/7/76 in GDC case number 35 of 73/74 of learned EM and the order dated 3/3/78 passed by the learned CM in GDC case number 12 of 1977-78 as directed by the Honorable High Court after going to all record and after due consideration of the earlier proceeding, led me to only think to try the case afresh. Subsequently, case litigated by the parties after this finding are rendered abundant. So, I refrain from taking consideration the subsequent cases, except the aforesaid 2 cases before the learned EM and learned CM. I am sure that initially a fresh inquiry by taking evidence of the parties and their witness by taking up the following issue will, in my view, finally solve, important my lord, finally solve the long pending dispute for acting nukmaship of the parties. Now, his suggested issue, whether the junction moment was released from the Aking after Ringme and Marak deserted the junction and moment. Number 2, whom the claimed people actually selected to Aking Nukma after Ringme Marak deserted junction moment and left the house of Zemse and Marak. Next page, my lord. Number 3, whether the documents submitted to GDC 35 were legally acceptable? The answer to this issue, I sincerely believe, will finally solve the dispute for Aking Nukmaship. The parties are directed to suggest issue in addition to the core issue mentioned above, if any, to submit the list of their witnesses and relevant further document, if any. All these steps should be completed immediately by May's date to enable me to take oral evidence of the parties and their witnesses. In view of the court order, further delay should be avoided to arrive at final settlement. Fix 15/5/2013. But thereafter, they have not taken any cases, my lord. Now I am coming to this another. Now I am coming to para 6, my lord. It is important.
Para 6 of what?
Para 6 of my additional affidavit. Page number 5, my lord. That the petitioner being aggrieved for not passing or providing the order 15/5/2013, my lord. They have not passed order, though fix it. Again, same thing they have illegality done by the district council, my lord. File a writ petition before the Honorable High Court, which was registered by WPC number 29/2013. And after hearing the parties, writ petition was disposed of by judgment and order dated 23rd September 2014 by quashing the impugned order. Impugned order is quashed, my lord, which one I have read? 10/1/2013.
So why, when the order was quashed, why you are reading?
My lord?
The order was already quashed.
No, it is already.
That, my lord.
No, it is coming this new writ petition, my lord. It is quashed in WPC number. I will tell you, my lord. WPC number 29, my lord. Again, yes. 29. Before is 247.
Please go ahead.
Yes. Now I am coming to this annexure 7, my lord.
Annexure 7?
Yes. After that,
this is the order which has quashed the.
Yes.
Already 10/1/2013 has been quashed by this order.
Yes.
Read only the operative portions.
Yes. I am coming to that order, my lord. Yes. Page number 68, my lord.
No, I said read only the operative order.
Yes, I will read the operative part.
That will
para
be
4, my lord.
Para 4.
Yes. It will be better, my lord, if you go for para 3 and 4. It is correlated. Only 3, 4.
Read.
Yes. Number 3. Mr. S. the learned counsel for the respondent number 1 to 4 submit that the bar that the executive member Garu Hills Autonomous District Council in short GSADC Tura had committed a bona fide mistake in passing the said order dated 10/1/2013, my lord. In the same date, they have passed 2 orders, 2 different content, my lord. As much as the said Nenkra Aking GADC number 5 2007 has not yet been disposed of. That is the contention of the district council, my lord. And what the executive members Tura intend to mean in that order is that the issue are framed which are in separate sheet, but there is no separate sheet. As they learned counsel for the respondent 1 to 4 contended that he is having the record of the proceeding of the Nankra Aking number 5 2007 and further contended that the concerned executive member GSADC Tura had also tendered an unconditional apology for bona fide mistake for not passing this order, my lord. He had committed in passing the order 1/1/2013. The said bona fide mistake in passing the order 1/1/2013 had been corrected to the extent that. Next para, my lord. I am sure that the initiating of fresh inquiry by taking evidence of the parties and their witnesses by taking up the following issues will, in my view, finally solve the long pending dispute for Aking Nokmaship of the parties without disposing, my lord, telling like that. Whether Junction Momi was released from Aking and after Ringme and Marak deserted Junction and Momin, whom the claimed people actually
not necessary to go through.
Yes, it is already mentioned before, my lord. Now, next, the parties are now number 4, my lord. That is the same which I have already read out. Now, number 4, my lord. In the course of hearing of the present writ petition, this court put question, important, my lord, to the parties whether or not the said Ankra Aking GADC review appeal number 5 of 2000 had been finally disposed of, or as to whether the submission of Mr. SD, learned counsel for the respondent 1 to 4, that the said bona fide mistake in passing the order 1/1/2013 had been corrected by the concerned executive member GSAG Tura to the extent indicated above or not. But my learned friend has not been able to reply on that point. To this question, the learned counsel appearing for the parties submitted that the case is still pending. They are telling it is still pending, but in other way they are telling it is already disposed of in the order. It had not been disposed of finally. In such circumstances, the abundant precaution of the order 1/1/2013, which read as follows: parties present heard their learned counsel submission, judgment and order pronounced in an open court, which is prepared in separate sheet, my lord. Whereas it is a totally a false.
Whatever the case may be.
Yes.
It is quashed. It
No,
is
no,
quashed.
no. You come to that point. We wait. Appeal
My lord,
is.
may kindly see, my lord. That has been quashed. We have tendered unconditional apology that there was some bona fide mistake. They are not a judicial officer, my lord. He is a CEM, my lord, and an administrator, my lord. He has made certain mistake. He had tendered apology, my lord. How it is related with the present order, my lord? We're just hearing him from last half an hour, my lord. How it is relevant when this matter has already been set aside?
Which order it was set aside?
This order has been set aside.
Then how the order, this order has been passed by the Honorable High Court, directing the last
So
order.
are we sitting in the review, my lord? Are we sitting in the review? This honorable court, my lord, can change this order. We are not sitting in the review, my lord.
I am not going for that. That order I am reading, that is the final order. After that, for that reason we have coming here. So we file this one, agree upon, before they are telling how the order is challenged. So I have given the sequence.
Now the order dated 10/1/2013 has been
quashed. Now this Now, that is I understood, my lord. Now this, with this order of 23/9/2014, what the court is saying, that one I am coming to that point.
If he is agreed, he should have filed an appeal against
No,
this
just a
order.
moment, just a moment.
It is already filed.
He never challenged
The
this
appeal
order.
is wait. The appeal is allowed.
Look at the
No,
portion.
the final order, my lord. Only 1-2 line is there.
Exactly.
Yes, I am coming to that. Appeal is allowed. That is our writ petition was allowed. The case stand disposed of is hereby quashed.
The appeal is not allowed, my lord. It's not the writ petition is allowed.
I understand. You don't have to tell me.
No, what they are stating in the order, I am
Mr. Hajira,
reading this one.
you read only the
Yes,
the last
as
last
submitted
two.
by the parties.
This is what is relevant.
Yes, the chief executive Tura shall proceed Nankra Aking GADC Tura Ato in according to law, my lord.
That means the case has been revived. And the CEM has to be decided afresh.
Yes.
So what was the relevancy of reading all these pages, my lord? Unnecessary 45 minutes. He has wasted the valuable time of this honorable court.
That is
And this order has been complied, Lordship.
And this order has been complied. We have passed an order of 12/2016.
Against that order only he is coming.
Yes, we'll continue.
Yes, this order.
We'll continue.
Yes.
Mr.
After that.
Yes, Mr. Hajarka.
Yes, then
We'll continue on next date.
No, my lord. That is the final order is there.
Exactly.
Yes, which one? In the writ petition.
Time is already up.
Oh. Then one order only, my lord. Yes.
Next week.
Next week, my lord. Next week.
May I please, your lordship? I will read only 10 minutes. I will take 5 minutes.
You can continue on the next week.
Next week.
Okay. It may be made part of my lord.
It's part heard, no doubt.
Yes.
Heard, Mr. A.H. Hazarika, letter counsel petitioner. Hearing is not concluded and will continue on the next date. Suggest a date.
Next week or this week, my lord? On
This
Thursday?
week may not be possible, my lord. Let it be on 13th, my lord. 13th of July, my lord. 13th of July.
13?
13.
That's Thursday.
Okay.
This is matter on 13.
Item number 14.
May please, Lordship. Lordship, I pray that this matter may be taken up after 1 week, Lordship. Lordship, I just got instructions from Madam N.G. Shella, the senior government advocate, that she's in this post. She had to run for some personal work.
You are for the petitioner?
Yes, Your Lordship. No objection.
On prayer made by the respondent, this is matter of the 2 weeks.
Highly obliged.
Second call from supplementary cost list, item number 3.
Lordship, I'll not take much time, but I'll draw your Lordship's attention to my synopsis. Lordship, the petitioner is the headmistress of Archival Higher Secondary School. This is in my synopsis, Your Lordship. Tura since 1993, which she co-founded with one Srimati Vaila Sonachi B. Sama, former chairman MP. Petitioner teaches economics to class 10 students and on request of parents of the students of class 1 and 2 conducts special class grammar classes to students of class 1 and 2 first period. A written complaint was filed on 25/4/2019 at about 10 p.m. before the officer in charge, Tura Women Police Station, West Garo Hills District, against the petitioner to the effect that the petitioner assaulted a class 2 student who is the daughter of the respondent number 5 on 24/4/2019. Tura woman PS case number so-and-so was registered against the petitioner under section 323 IPC, read with section 75/82 of the Juvenile Justice Act 2015. The petitioner came to learn that the said case was registered against her only on 29/4/2019, when the IO summoned the petitioner to the police station. In fact, a social media post was circulated on 25/4/2019 through WhatsApp, etc., that the petitioner had assaulted the student of class 2 even before any written complaint. The IO submitted charge sheet number so-and-so on 28/10/2020 under section 323 IPC, read with section 75/82 of the GG Act 2015. A prayer for discharge was made by the petitioner before the trial court, that is Judicial Magistrate First Class Tura. After hearing parties, Learned Trial Court passed order dated 14/1/2022, directing framing of charge under the opposite section of law. On revision, Learned Session Judge Tura, while holding that section 82 of the GJ Act 2015 is not attracted, since there is no material to frame charge under the section. However, holding that there is a prima facie case under section 323, read with section 75 of the GG Act 2015. Thereafter, Learned Trial Court passed order dated 23/5/2023, holding that charge be framed against the petitioner under section 323 IPC, read with section 75 and section 82(1) of the GJ Act 2015, and has posted 14/7/2023 for framing of charge. Just for a moment, Your Honor. In fact, section 82 has been set aside by the session court, but the trial court again wanted to frame charge under the sections forwarded by the IO. Now I come to next page, Your Honor. It is the stance of the petitioner that, number one, the FIR was registered on 25/4/2019 at about 10 p.m. on the basis of a written complaint, and the charge sheet number 75/22 under section 323 IPC, read with other sections, was filed before the court on 28/10/2020 by the IO police. Whereupon the Learned Trial Court took cognizance of the case on 14/1/2022, that is Annexure 1, clearly revealing on the face of the record that the cognizance was taken by the court after a clear 2 years and 8 months from the date of alleged occurrence, Your Honor. Firstly, cognizance of an offence under section 323 IPC as taken by the Learned Trial Court vide order dated 14/1/2022 on the basis of charge sheet dated 28/10/2020 is clearly barred under section 468 CRPC, and the trial in GR case number so-and-so is thus vitiated, being illegal and being without jurisdiction. Secondly, in terms of section 1(4) of the Juvenile Justice Care and Protection of Children Act 2015, the provisions of the said Act shall apply to all matters concerning children in need of care and protection and children in conflict with law. The said section under clause 1 and 2 further elucidates the inclusive definition of children in need of care and children in conflict with law. Your Honor is very aware of that. This law is applicable with children in need of care and children in conflict with law. Further, section 2(13) and 14 specifically defines the two terms child in conflict with law and child in need of care and protection exclusively in elaborate manner. None of these definitions and provisions of section 1(4) read with section 2(13) and (14) of the Act of 2015, even in their widest possible interpretation, can include the student, daughter of R5 in question, as mentioned in the FIR, within the periphery of the ambit of section 75 of the Act of 2015. Consequently, no trial or any offences under section 75 of the Act of 2015 can proceed in the instant case based on the FIR number 17(4)19 as well as a charge sheet number so and so dated 28/10/2020. It is the case of the petitioner that no trial or further proceeding in GR case number so and so 59 of 2021 under section 323 read with section 75 of the JJ Act 2015 can proceed any further under any tenets of law against your humble petitioner. Number 1. As the period of limitation for taking cognizance of offence under section 323 has lapsed at the end of 1 year of the registration of the case, date of FIR dated 25/4/2019. And number 2. Also under section 75 of the JJ Act of 2015, in view of the provisions of section 1(4) and section 2(13) and (14) of the said Act, having clearly denuding the contents of the FIR bereft of any ingredient for constituting an offence, even prima facie under section 75 of the JJ Act, that the aforesaid legal infirmities is very important for this honorable court, your lordship, that the aforesaid legal infirmities and basic jurisdictional issues are prima facie born of the record of the case and not result of any factual dispute being raised by the petitioner accused. The issues are apparent on the face of the record, which deserves primary consideration of your lordships before an order in the nature dated 23/5/2023, Annexure 2, could have been passed ordering resumption of framing of charge against the petitioner accused. For that, in any view of the matter, the entire proceeding under GR number so and so, pending before the Court of Judicial Magistrate First Class Tura, emanating from Tura PS case number so and so, are liable to be quashed for ends of justice. That it is a preeminently fit case where the record of the entire proceeding impugned before your lordship be called for before this honorable court for judicial scrutiny of your lordships, and the proceedings in GR case number so and so be quashed, being prima facie against the tenets of law, so as to render justice to the humble petitioner who has already undergone trauma, humiliation, and harassment for no fault of her own. Your Honor, the lordship, the prayer is at page 14. In the premises of aforesaid, it is therefore prayed that your lordships be pleased to admit this petition and issue notice to the respondent, call for the records of GR case number 59/21 pending before the Court of Judicial Magistrate First Class, West Garo Hills, Tura, and upon hearing the parties, be pleased to set aside and quash order dated 14/1/2021, Annexure 1, order dated 23/6/2022, Annexure 3, order dated 23/5/2023, Annexure 2. Then entire proceeding in GR case number 59 of 2021 emanating from Tura PS case number was 17/4 of 2019. In the meantime, your lordship, be pleased to stay further proceeding of GR case number 59 of 2021 pending hearing and disposal of the instant matter and or pass any other order. That's my limited prayer, Your Honor, before this honorable court. Your Honor, the law is very clear, the mandates are very clear.
The parties will be heard.
Yes, Your Honor.
Who is appealing?
I'll accept notice on behalf of the state respondents, Lordship. 1, 2, 3,
4.
and 4.
And
number 5, I will send by, if this court permits, by registered post.
You take steps. But Mr. BGK Kanta, the senior counsel appearing for the petitioner. The state respondent 1, 2, 3, and 4 respectively are duly represented by Mr. Ishkarmi Leonard, additional petitioner. The petitioner is, however, required to take steps on respondent number 5. The same returnable within 2 weeks. In the meantime, the state respondents directed to file copies of the proceedings of the court in, where is the case number?
GR case number 59/21.
GR case number 59 of 2021 pending before the Court of the Judicial Magistrate First Class,
West Garo Hills,
Tura. This is matter for 2 weeks.
Interim prayer, you know.
Let the respondent appear and then we'll hear the matter finally.
Yes.
Much obliged.
Much obliged.